Okay. I think I've been saying that secure transactions has several distinct stages from a transaction viewpoint. That if you're trying to put together a secure transaction, then there are several stages that you have to keep in mind. The first stage, of course, is the creation of the security interest. And I think I have this thing called CRAFS in order to give you one word to remember for all the 5 stages of secure transaction. So the first CR means that you must create a security interest. And the creation of a security interest is by means of a contract. And that's why a secure transaction is a contract transaction. It is a consensual transaction. It is not coercive transaction. Nobody can force you to enter into a secure transaction. So creation, and what you're creating is a security interest. And security interest, as I was saying in past few classes, is a contingent property right that the debtor gives to the lender. And the purpose of this contingent property right is that if I default on my loan, says the debtor to the lender, then you can exercise this security interest, and without going to the court, you can possess the identified collateral and sell it in order to get your money back. So this concept of security interest is a contract-based property right, that you create a property right by means of a contract. But the secured party or the lender cannot exercise this property right until default occurs. So I think this is a unique property right. For example, if you have a lease, then you have the right to possess and use the property. And you can begin to use the property right away after you lease it. If you own the property, of course, you can have even more rights to the property. You can use it, you can sell it, you can do whatever with your property. But security interest is a property right that stays there until default occurs. And you have, no rights to the collateral until default occurs. And we do know that some security interests are possessory and some security interests are non-possessory. Now, a possessory security interest is where the lender possesses the collateral. And a non-possessory security interest is where the lender does not possess the collateral. Now, historically, common law only allowed possessory security interests, and non-possessory security interests were considered fraudulent. So a secure transaction under common law was one where the lender had the possession of the collateral. But as I was saying in previous classes, that we have turned the common law upside down. We still have possessory security interest, but most secure transactions are non-possessory in the sense that the debtor gets to keep the collateral, and the lender rarely possesses the collateral. And particularly in the case of financing collaterals, which is a big part of secure transactions these days, that you don't have the property and you don't have the money to buy the property. And financing helps you get both. I think that's a remarkable invention of the capitalist markets, that we will give you the money and we will give you the thing that you want so that you can have it, both. But financing presupposes that the debtor has the ability, monetary ability, to pay off the loan in a structured way. So if your cash flow is good, if you can afford to pay monthly installments, then I think the markets are open for you to finance the things that you need. So the creation of a security interest by means of a contract is the first stage of a secure transaction. The second stage is represented by A, and that is attachment. Now the security interest must attach to the collateral. Unless it attaches to the collateral, security interest is not enforceable. So the enforceability of a security interest is distinguishable from the creation of a security interest. Just because you create a security interest does not mean that it is automatically enforceable. The enforceability or attachment security interest takes place when 9203 elements are met. And 9203 is one of the founding sections of Article 9. I think you have to master 9203. All the elements of 9203 it's a long section, but you have to master 9203. And I will get to attachment in a second, more deeply. So the third stage of a secure transaction is represented by P, and this is perfection. And perfection of security interest is that you give notice to the public, which means to other lenders and buyers who might buy the collateral, that you have a security interest in the collateral. So perfection is a method of giving public notice, or it is a public notice to the lenders and the buyers. Now historically, under common law, the only method of perfection was possession. And the common law did not come up with the idea of central filing system, where you announce to the public that you have a security interest in the collateral. But in the US now, all 50 states have a filing system, and you file a financing statement giving some critical information there, like who's the debtor, who's the secured party, and what is the description of the collateral. These three things constitute the critical information of the financing statement. And when you file the financing statement in public records, which is then accessible to the public, you have perfected your security interest. And that means anybody who has a security interest subsequent to your date of filing is going to be a junior creditor, and you will have the first right to get your money back over and above the junior creditors. That is what we call temporality rule. Of course, there are exceptions to it. So the purpose of perfection is to stand in a queue and reserve your place in the hierarchy, so that you know that what are your chances of getting your money back if the collateral is sold. And the third P, the second P is priority or competition. And Article 9 does have priority rules. That if there are more than 2 or 3 people going after the same collateral, then how do we sort them out? How do we rank them? And of course, temporality rule is one of the basic competition rules under priority. That security interests which are all perfected, whoever perfected first or filed first is going to be ranked first. If all competing security interests are unperfected, what I call oopsies, then again the temporality rule applies. But now the question is who attached first. So priority or competition means ranking the lenders, or ranking the lenders and the buyers if they're buyers. So don't think that ranking is only between lenders. Ranking could be between lenders and buyers. And then the S at the end, CRAPS, the S is for sale or settlement, and which we have not covered yet. That when default occurs, the collateral can be sold. So CRAPS, creation, attachment, perfection, priority, and sale. These are indeed the 5 stages of a secure transaction, from creation to the final resolution. I mean, S is more like when default occurs, post-default, S. If default doesn't occur, then really maybe the first 2 stages are important. If default does not occur, perfection and priority and sale, they become irrelevant because nobody's going to sell the collateral. And most secure transactions are not defaulted, and that's why they are, meaningful. Because if every secure transaction was defaulted, then nobody's going to engage in secure transactions. So the good news is that from a transactional viewpoint, if you structure a transaction according to law, then it will go through. And I think your job as a transaction lawyer is to minimize the possibility of default and to make sure that the transaction goes through. And I think that's what you are paid for as a lawyer. Now, so remember, whenever you are trying to read for the exam, Article 9, remember this broader structure. And even when you're attempting to solve a problem, I think you ask yourself, well, in this CRAPS, where is the problem? Is the problem in the creation of the security interest? Is the problem in attachment? Is the problem in perfection? Is the problem in priority? Is the problem in the sale of the collateral? So from a litigation viewpoint, if the transaction goes bad, then I think as a diagnostic lawyer, you are going to ask yourself, well, where is the problem? Where's the pathology of the dispute? In which stage? It could be that more than one stages are involved in the litigation of the secure transaction. But I think, again, this will help you diagnose where the problem is. Particularly in exam, I think you don't have to say, well, let me first tell you that there was a creation, there was an attachment. You don't have to go through the 5 stages. I think that's unnecessary waste of time. Just see where the problem is and zero in on the problem rather than giving me back all the 5 stages. Now, we also talked about classification of the collateral. I think learning Article 9 is learning the classification of collateral also. And broadly speaking, the collateral can be classified in 3 broad categories. The first is goods. Second is payment rights, and then anything that doesn't fall between in the first 2 categories. Now again, historically, secure transactions were about goods. And more recently, we have expanded the definition of personal property for the purposes of the credit market. And now all sorts of payment rights are used as collateral. in order to get norms. So, very broadly speaking, you could say that Article 9 collaterals are either goods or payment rights. And then if nothing fits between the two, then there might be a third category, residual category. For example, general intangibles. They are not goods, they are not payment rights. Like intellectual property. Intellectual property is not goods, even though it can be used in goods. And intellectual property is not payment rights, even though intellectual property may be licensed for a payment right. So intellectual property would fall into general intangibles. And I think general intangibles is a very broad residual category. And a lot of collaterals might actually fall into the general intangible. Now, with respect to goods, we have 4 subcategories. Of course, inventory is one, and then consumer goods, and then farm products, and then equipment. Now, equipment again is a residual category, residual subcategory within goods. So, if you cannot, classify goods as inventory or farm products or consumer goods, then it's going to fall into the residual category, which is equipment. And payment rights are, for example, instruments, promissory notes. They are payment rights. When you write a promissory note or when you obtain a promissory note, you might have a payment right. In fact, you do have a payment right exhibited by the promissory note. Remember, whenever there's a payment right, there's a payment obligation. And the person who has the payment obligation is usually called the account debtor. So an instrument, if I own it, somebody is going to, I have the payment right. And the person who's obligated to pay the promissory note is the account debtor. Similarly, chattel paper is a device which has a payment right in it. The entire chattel paper is not payment right, but chattel paper has a payment right attached to it. We also define chattel paper as a record which has a security interest plus a monetary obligation. So of course the account debtor is going to have the monetary obligation, and if you own the chattel paper, you have the payment right. So see this, that wherever there is a payment right, there is a monetary obligation. And then accounts is also a payment right, and somebody is going to have monetary obligation. Deposit account should be distinguished from an account. Deposit account is something you open with a bank in order to deposit your funds and in order to withdraw your funds. And deposit account is a perfect collateral in order to get a loan against deposit account, but should not be confused with account. So payment rights can be collateralized. You can collateralize account, you can collateralize instruments, you can collateralize deposit account, and you can collateralize chattel paper. You can collateralize payment intangibles in order to enter into a secure transaction. So I think classification is important because there are different methods of perfection. Some collaterals will be perfected. Security interest in some collaterals will be perfected in one way and in another way. Now remember, what you are perfecting is a security interest. You are not perfecting the collateral. And I want you to be very careful about Article 9 language. What you're creating is a security interest. What is being attached is security interest. What is being perfected is security interest. What is being prioritized are security interests. And I want you to be very careful about the use of language. I don't want you to say the debtor has been perfected, or the secured party has been perfected, or secure transaction has been perfected. No. Security interest has been perfected. If you look at the slide, you will find that collateral is the key concept that is at the heart of the secure transaction. And at the heart of the collateral is the security interest. Because a collateral is defined as property subject to security interest. So, if you look at the collateral, then you will find that debtor is a person who has rights in the collateral. Secured party is securing the loan by means of the collateral. And a security agreement is a contract that creates security interest in the property and turns property into collateral. So collateralization of property is secure transaction. And unsecured transaction would be where there is no collateral. And somebody is giving you a loan because of your personal credit rating. But here, the collateral, whether it is goods or payment rights, is critical to the definition of a secure transaction. Now, as I said, attachment is the most important concept of secure transaction. Because without attachment, security interest will not be enforceable. And there are two big ways in which attachment can occur. And you can say that attachment could be with respect to non-possessory security interest, or attachment could be with respect to a possessory security interest. So first ask yourself a question. Is the attachment taking place with respect to a possessory security interest or a non-possessory security interest? Because if it is a non-possessory security interest, which means that the lender is not going to possess the collateral, then you need an authenticated security agreement which describes the collateral. If it is a possessory security interest, then you don't have to have a written or authenticated record of a security agreement. You can have an oral security agreement, even though that's not advisable. I think it's always advisable to have a record, an authenticated record of the security agreement. But technically, under law, you don't need an authenticated record of security agreement if you have possessory security interest. But if you don't have possession of the collateral, and if the lender is not going to possess the collateral, then you've got to have an authenticated record of security agreement. Very important, simple point. And in that record, you must describe the collateral so that if default occurs, you know what collateral to possess and sell. So you could say that the description of the collateral and possession of the collateral are two parallel things. You got to have one of the two. Either you possess the collateral or you describe the collateral in order your security interest to become enforceable. This is the distinction between possessory and non-possessory security interests. But two things are common in all forms of attachment. One is that the lender must be a value, mostly a loan, but it could be another value. We didn't get into what possible values are, but I think we kept it simple. That value means, money coming from the lender to the debtor. And so this is value must be given. If you don't give value, security interest is not going to become enforceable, even if you possess the collateral. So value is critical. And second, that security interest is not going to become enforceable unless the debtor has rights in the collateral. Makes sense. You cannot pick somebody else's property and offer it as collateral. You must have some legal rights to the collateral. Now, it is not required that you own the collateral. Ownership is not required. You've got to have some rights in the collateral. Now, as far as perfection is concerned, there are three methods of perfecting the security interest. Of course, Article 9 recommends filing of a financing statement. Almost all secure transactions will allow you to file, but not all. For example, with respect, if money is the collateral, you have to possess it. You cannot file. In the case of deposit account, I think you control the deposit account. And that is the method of perfection. The second method of perfection is that you possess or control the collateral. Of course, if the collateral is tangible, all goods are tangible, therefore goods can be possessed. But there are some payment rights which are tangible ones. For example, if a payment right is represented by a tangible chattel paper, you can possess it. Tangible chattel paper can be possessed. Similarly, if a payment right is represented by an instrument is a paper instrument, you can possess the instrument. Paper documents can also be possessed. So paper can be possessed. So if a payment right is been reduced to paper, then paper can be possessed and possession can be a method of perfection. So if it is a paper promissory note and you possess the promissory note, you have perfected your security interest in the promissory note. Now, if the collateral cannot be possessed, either it is not goods or it is not reduced to paper, then we have the concept of control. For example, electronic chattel paper can be controlled. Electronic instrument can be controlled. What is another thing which is electronic? I don't know. Is there anything other than electronic chattel paper, electronic instruments? Is there anything else that is electronic? No. Now, accounts cannot be controlled. Very interesting. The only method of perfecting a security interest in account is to file. this is a little secret of Article 9. No section of Article 9 says that security interest in accounts can only be perfected by filing. But this is like, residual rule. If you, read all the rules, you'll find that there's nothing about account. But there's a general rule that you must file a financing statement to perfect security interest. So it falls into that general rule. But I think there are specific sections which say that you can perfect security interest by possession of tangible chattel paper, or you can control electronic chattel paper, but nothing about account. So security interest in account can only be perfected by filing. No possession, no control. In money, you can perfect only by possession. And in deposit account, only by control. There's little exception to deposit accounts, which we will probably discuss later, but as a general rule. And then there's automatic perfection, where you don't have to do anything. Once the security interest attaches, it becomes perfected. And there are 11 or 12 scenarios where perfection is automatic, and you don't have to do anything. The most important thing that we studied was that if you have a purchase money security interest in consumer goods, then you don't have to file or possess or control. It's automatic perfection upon attachment. Now, automatic perfection means perfection upon attachment. That if attachment occurs, perfection automatically occurs without any additional step. Now, I think one thing that I have been clarifying over this semester is that please don't confuse filing with perfection. And I have video on it, and I try to clarify it several times. A lot of people think that filing is perfection. Huge difference. Filing is a method of perfection. And because you can file at any time of a secure transaction, even before a security interest is created, filing does not mean perfection. Perfection occurs subsequent to attachment. Filing can occur before attachment, before the creation of security interest, after the creation of security interest. You can file any time. But perfection can only occur after attachment. I think this is the basic distinction. So attachment plus filing is perfection. So if there is filing but there's no attachment, there's no perfection. And of course, there cannot be attachment without creation of security interest. So you can say that it's sequential, that creation precedes attachment, and perfection succeeds attachment. So first comes creation, then comes attachment, then comes perfection. Of course, all three things can happen simultaneously also. But if you have to separate them in time, then this is the sequence: creation, attachment, perfection. But if you can squeeze them into the same moment, then that's fine. Now this is only, I think, more elaboration that what collaterals can be possessed. Of course, goods can be possessed, money can be possessed, instruments can be possessed, negotiable documents, if they are paper, can be possessed, tangible chattel paper possessed, certificated securities. This is the type of investment property we were talking yesterday. That investment property could either be certificated securities or uncertificated securities. So if they are certificated securities, they can be possessed. Now remember that possession is both for attachment and perfection. If it is a possessory security interest, then you're using possession as an element of attachment. So possession can give you both attachment and perfection. Very important point, simply. That possession can give you two things: attachment plus perfection. And in addition to goods, anything which is in a paper form can be possessed. And then control, which is the sister of possession, will be with respect to three things: electronic gel paper, deposit accounts, and investment property, which is not certificated security. So if investment property is not reduced to paper, because investment property are rights to property, like rights to share in the company, rights to securities accounts, rights to a commodity contract, rights to a commodity account. So you will see that investment property can be controlled if it is not in the paper form. And deposit accounts, of course, can be controlled. And I explained that when you say you have control of a deposit account, it means you can withdraw funds without the consent of the owner of the account. So let's say that that you have a deposit account where you deposit your checks, but at any given time there are $10,000 in your deposit account. Now, if you give this control to some lender over your deposit account, that means the lender can withdraw funds from your deposit account without your further consent. And this would only happen when you and the lender and the bank will enter into an agreement that the lender can withdraw funds from your account, and the bank would allow them to do so. So that is control. Yeah?
Can a debtor get control to more than one lender?
That's going to be messy.
Okay.
Because if you give control to more than one person, then I think, I don't know if you can do it or not.
Just wondering.
But it seems like it's prone to conflict. And I think we have talked about automatic perfection, and that is purchase money security interest in consumer goods. Please keep in mind that it is not every purchase money security interest is automatically perfected. This is the common mistake I see. Only in consumer goods. All other purchase money security interests must be perfected by filing or by control or possession. So only purchase money security interest in consumer goods, and not in any goods, but only in consumer goods, is perfected upon attachment. Now, priority. Very simple, that all perfected security interests beat unperfected security interests. That's what I call the league competition. One league is superior to the other. Perfection league is superior to unperfection league. So whenever a perfected security interest is competing with an unperfected security interest, Percy is going to win. Perfected security interest is going to win. Regardless of temporality. Temporality does not matter. If a perfected security interest is competing with an unperfected security interest, which means, let's say that the unperfected security interest attached in 2009, but perfected security interest was perfected in 2011. Perfected security interest is going to win, regardless of temporality. So this is what I call, league competition. That one league is always going to win, regardless of time. In the middle, you see LC, and we have not discussed this. This will be the lien creditor, bankruptcy trustee, and we're going to discuss this later. So we will see that later. Now, when does the temporality rule become a competition rule? It becomes a competition rule when the competing security interests belong to the same league. Let's say two perfected security interests are competing. The first to perfect or file will win. If two unperfected security interests are competing with each other, the first to attach is going to be the senior security interest. That means they're going to get their money back first if the collateral is sold. Now, what does priority mean? That if the collateral is sold, who will get their money back first? I've also been saying if there is enough value in the collateral that all secured creditors can be satisfied, there's no competition. Competition occurs only when the secured creditors cannot all be fully satisfied, when they cannot get their money back completely. Then we have to rank them and say, okay, somebody has to take the loss. So you could say that priority is loss allocation rule. That competition rules are loss allocation rules. I think that's a good way to understand competition rules. That how do we allocate loss when loss has to be allocated? So if there's no loss, we don't need competition rules. So temporality only within the same league, and temporality doesn't matter if security interests belonging to different leagues are competing. I think that's what you want to remember. Okay, we have already discussed it. Okay, now there's a confusion between perfection and filing. Because we are saying, first to file or perfect. And I think we discussed this in class. That in order to preserve the filing system, even though you perfect it later, but if on default, two security interests are competing, and one perfected later but filed first, we're going to go with the filer. Because otherwise, the filing system cannot be preserved. So we will give priority to the security interest which was perfected by filing, and filing preceded in time the other filing or the other method of perfection. I think that's another little twist that you have to remember. First to file and first to perfect. How do you understand that? Because first to perfect may not be the first to file. But the critical question is, on the time of default, are the competing interests perfected? Yes. Okay, they belong to the same rule. Now we apply the temporality rule because they belong to the same rule, same league. Then we say, okay, who perfected first? Well, A perfected first and B perfected later. But B filed first. So B is going to win. So this is, that priority is given to the person who perfected by filing first. a little screwy, but I think it becomes clear if you think about it. And we have talked about this, that if there are two security interests, both are oopsies, then first to attach. Good well. And I've also explained this, that PIMC, only if it is perfected, is exempt from the temporality rule. And this is an exception to the temporality rule. That both security interests are perfected, therefore they belong to the same rule, same league, and yet temporality rule doesn't apply. And here we're going to say, okay, one is PIMC, the other is non-PIMC. Both are perfected on the time of default. The non-PIMC filed first or perfected first. PIMC came later, they perfected later in time. Well, under the temporality rule, they should lose, but they don't. They win. And we have analyzed why PIMC, perfected PIMCs are given priority, because this is asset infusion, and asset infusion does not harm the prior lenders, because the alternative is that asset won't be infused into the business. And I think some of you have written the memo on whether unperfected PIMC should also be given a similar priority, and the answer is right now the system does not. Article 9 does not give any priority to an unperfected PIMC competing with an unperfected non-PIMC. So an unperfected PIMC is treated as a regular standard security interest. Only when it is perfected does it have darling status or becomes exempt from the temporality rule. Now, that's another thing, survivability thesis, my phrase. Article 9 used the word continuation. It says that a security interest continues upon the disposition of the collateral. I say security interest survives at the disposition of the collateral. Same thing. So this is the general rule, that security interest does not vanish if the collateral is sold or exchanged or leased, but it goes with the collateral. In fact, upon disposition of the collateral, lender has two security interests. First, he has the security interest in the collateral, and then the lender has security interest in the proceeds. So in some ways, this position is good for the secured lender, for the secured party, because all of a sudden now secured party has two security interests, whereas before the secured party had only one. So survivability thesis, the general principle of law, Article 9, that security interest survives the sale of the collateral, which means that it goes with the collateral. And if default occurs, you can go after the collateral from the hands of the buyer. So buyer cannot say, well, I bought it. Okay, you bought it, but it's still subject to security interest. Security interest survive. Now, survivability thesis is has to be balanced against free alienation thesis. Free alienation thesis, I don't know if you have discussed this. Free alienation means that the debtor should be free to alienate the collateral or sell the collateral. We don't want to put too much restriction on the sale of the collateral. In fact, Article 9 very clearly says that even if there is a contract between the lender and the debtor not to sell the collateral can still be sold, even though it would be a breach of contract. And there could be a remedy for breach of contract, but the collateral will be sold, and we will have to allocate competition between the buyer and the lender. So this is the two broad theses: survivability thesis, free alienation thesis. Survivability thesis means that security interest survives. Free alienation means this collateral can be sold. Now, the broader principle is that a biocop takes free of security interest. And this is what we want to protect the goods markets. That in goods markets, if you're buying stuff from merchants who are in the business of selling those goods, you should be able to take those goods free of security interest. And so this is a big thing in terms of free alienation thesis, that it supports free alienation, that you can take a collateral, you can buy collateral free of security interest if you are a biocop. And biocop means buyer in ordinary course of business, which means you're buying for value, you are buying from a merchant who is in the business of selling those goods, you are buying in good faith, and you don't have any knowledge that this purchase is going to be in violation of anybody's rights. Knowledge of security interest is irrelevant. You could know that the thing you're buying is subject to a security interest. You could know that this collateral you're buying is subject to a perfected security interest. Doesn't matter. You take free. And I think this rule has been adopted in order to protect the goods market, free alienation of goods market, or free alienation in the goods market. In other cases, if you are buying collateral from a person who's not in the business of selling those goods, then I think Article 9 provides a balance between the rights of the lender and the buyer. Again, it's competition between the lender and the buyer. And the competition is that if the security interest is perfected, lender is always going to win. So if the collateral is bought from a non-merchant, the lender, if they have perfected their security interest, they'll win. And the buyers, are out of luck. If the security interest is not perfected, then the buyer has a chance to take free of security interest. I think this is 9317. So I think 9317 should be contrasted with 9320. 9320 is biocop, 9317 is buying stuff from non-merchants. If you're buying stuff from a non-merchant, you should check the financing statements and see if the security interest has been perfected. If the security interest has not been perfected, go ahead and buy it. You'll take free of security interest. But you must check the records. But if you're buying it from a merchant, you don't have to check the financing statements because you're going to take free of security interest even if it is perfected. So why check, right? But if you're buying it from a non-merchant, then in order to take free of security interest, you want to make sure that there is no financing statement that shows that some lender has perfected their security interest in the collateral that you're buying. Then we have proceeds. Whatever is obtained upon the sale of a collateral is proceeds. I mean, that's one definition. But I think as I discussed in class, the definition of proceeds is much large. It's a very expanded definition. And remember, Article 9 is designed to protect the credit markets. It is designed to protect the creditors. It is designed to protect the lenders. So one way to protect the lenders and the credit markets is to expand the definition of proceeds. And proceeds give protection to the lender because if default occurs, lender can go after the proceeds. So if you sold the collateral and got a check is proceeds. If you sold the collateral, got cash, cash is the proceeds. If you sold the collateral, got a chattel paper is the proceeds. If you sold the collateral and opened an account, account is the proceeds. So you'll find that whatever you acquire upon the sale or exchange or lease of the collateral, it's going to be proceeds, and the lender will have the right to go after the proceeds to get their money back. And I think we discussed that how the concept of proceeds has been expanded to give even more protection to the lenders. Now the question is, why do you have a perfected security interest in the proceeds? And again, there we have a couple of rules. One is that if you have a perfected security interest in the original collateral, then you will have perfected security interest in the proceeds. That's the larger principle. That you're going to get a perfected security interest in the proceeds. But then the only question is, for how long? Is it give you time to re-perfect, or is it forever? And there we have a distinction between cash proceeds and non-cash proceeds. And the law is that if it is cash proceeds, then your security interest is going to be for an indefinite. Perfection is going to be an indefinite period. But if it is a non-cash proceed, then the rule is a little more complex. Then the law asks you, okay, you know, have you perfected your security interest in a very broad way that includes the classification of proceeds? If it does, then you're fine. If it doesn't, then you have 20 days to re-perfect. So in other words, you are given 20 days to sort out whether you need to file a new financing statement to perfect your security interest in the proceeds or not. In some cases, you don't have to file. In some cases, you have to file. And I think 315 clarifies that under what circumstances you need to file a new financing statement to perfect your security interest in non-cash proceeds. Again, I think this rule is for the benefit of the, and I think that's enough for today. Thank you. Do you have another